All right, people, I have exactly one take for this because my wife, she knows when I have to do something. She can tell it in my eyes. Determination, obsessive compulsion, who knows what it is. I did a couple of videos yesterday and the day before summarizing the absurdities of the majority decision coming out of the Colorado Kangaroo Court. That's my new term for it, by the way. It's the Colorado Kangaroo Court or the Kangaroo Colorado Court. Colorado Kangaroo Court has a better ring to it, so let's make that hashtag trend. I've done two breakdowns of the decision, the majority decision. I read the dissenting opinions, and I said, that needs a video of its own. I was going to do it tomorrow, but tomorrow I'm traveling back to Commie, Canada, and I don't know if I'll get to do it tomorrow, so I'm doing it right now. I know I only have about 10 minutes for this. I did not say I was going to the bathroom tonight. This is straight up. I've got one take, going to break it down. The dissenting decision, the dissenting opinions, because there's three of them. People are saying, oh, it's a Democrat court of 7 Democrat judges out of Democrat Colorado. They're right. And even under those circumstances, 3 of the 7 justices said, holy crap, is this a bridge too far for us? Now, I'm going to focus on Judge Samour. His name is Armando Samour Jr. I'm going to focus on his dissent in particular, but there was a good one by Boatright, which came before, and you can read them. They're phenomenal. But I'm going to focus on a couple of things in particular. I've highlighted it. I've posted to Twitter. I've shared this with our locals community. Gonna have to take my glasses off again. Justice Boatright is one of the 3 dissenting judges. In conclusion, stated as follows. I'm just going to read this because it's beautiful. I'm not going to edit the snippets in, but you can go check it out on Twitter because I posted it there at the viva Frei. Conclusion. My opinion is that an inadequate cause of action is dictated by the facts of this case, particularly the absence of a criminal conviction for an insurrection-related offense. Look, every now and again, I make myself feel smarter than I deserve to make myself feel smart. I've been saying no conviction, let alone a charge, and the majority decision found a way to summarily dictate, based on colloquial interpretations of what insurrection means, that Trump engaged in insurrection through omission, that they disqualified him under the 14th Amendment 3rd subparagraph, which arguably does not even apply to the president in the first place. I'm like, nobody was charged with insurrection, let alone convicted. And when I say that these dissenting judges give what I refer to as a judicial smackdown to the majority, they do it, and this is how they do it when you want to be polite in judicial terms. My opinion is that, this is paragraph 271, my opinion, read it in a British voice, it'll make it less offensive, is that an inadequate cause of action is dictated by the facts of this case. Translation, y'all pulled it out of your kangaroo court buttholes. You pulled it out of your kangaroo pouch is what you did. Particularly the absence of a criminal conviction for an insurrection-related offense. Seems pretty common sense to me. Paragraph 272. The questions presented here simply reach a magnitude of complexity not contemplated by the Colorado General Assembly for its election code enforcement statute. In other words, when you guys gave yourselves the power under some Colorado rules of election procedure to declare someone disqualified under the Constitution, yeah, you didn't have the power to make that determination because that's a federal determination. Justice Samour gets into it in a little more detail, which we'll get to. Got to stop interrupting myself. The proceedings below ran counter to the letter and spirit of the statutory time frame because the electors' claim overwhelmed the process. No poo-poo, Sherlock, because, as Justice Samour goes into detail, they violated every delay, even under their own state statute. Because it was so complex, they couldn't possibly hear this case in any reasonable time frame. And they violated their own rules, their own state rules and regulations for the procedural time frame, and basically declared someone invalid for running for president, you know, the leading candidate. Nothing odd about that. In the absence of an insurrection-related conviction, not even a charge, a conviction, according to Boatright, I would hold that a request to disqualify a candidate under Section 3 of the 14th Amendment is not a proper cause of action under Colorado's election code. Therefore, I would dismiss the claim and issue here. Accordingly, I respectfully dissent. I like to say that in the court of law, when judges want to when judges, listen, I want to do it. When judges want to smack down other judges, come on in, Winston, please hurry up. When judges want to smack down other judges, what do? They say, I respectfully dissent. You know, when I put on Twitter, respectfully submitted, it's not tongue-in-cheek. It's not to be rude. It's actually just to show what I'm trying to be respectful on Twitter, and when I'm not trying to be respectful on Twitter, the world knows it. Yes, that's right. Nibble at my goatee, dirty dog. Okay. But when a judge says respectfully, it's because they are angry with their colleagues. And no one was angrier, and let it be known, than Justice Armando Samour Jr. It's amazing. Just going to highlight the highlights. I'm going to talk about the highlights. I'm going to have to take my glasses off. Y'all know how I don't like being seen without my glasses. Justice Samour, I believe this is Justice Samour's decision. Listen to this. This is truly damnable, condemning. Thus, based on the interpretation of Section 3, our court sanctions these makeshift proceedings employed by the district court. Listen to this, and I highlighted this. Which lacked basic discovery, the ability to subpoena documents and compel witnesses, workable timeframes to adequately investigate and develop defenses, and the opportunity for a fair trial. This is coming from the judge. This is coming from one of the 3 dissenting judges saying this entire Kangaroo sham proceeding denied, and I'm quoting, the opportunity for a fair trial to adjudicate a federal constitutional claim, in brackets, a complicated one at that, and brackets, masquerading as a run-of-the-mill state election code claim. My goodness, is that a judicial smackdown? And because most other states don't have the election code provisions we do, they won't be able to enforce Section 3. That, in turn, will inevitably lead to the disqualification of President Trump from the presidential primary ballot in less than all 50 states, thereby risking chaos in our country. This can't possibly be the outcome the framers intended. When I talk about judicial smackdowns, and polite ones at that, rude ones disguised as polite ones, that's it. Justice Samour, my goodness, something tells me Justice Samour might be voting Trump. We move along here. Justice Samour gives a very, very lengthy historical analysis of the context of Section 14, subparagraph 3. And I do admit, for me to understand the historical context, I'm going to need Barnes to break it down, summarize it, and then dumb it down into terms. Explain it to me like I'm Canadian, ELIC. I'll need that. I appreciate that I can't get the full nuance out of it, and it's something of a weakness in terms of my historical contextual interpretation of things. What I can do, however, is read words. Listen to this, paragraph 281. Thus, the indelible trespass of the former... Oh, this was the history of the historical context. Such is the contextual framework informing my view of the instant matter, paragraph 281. To my mind, it compels the conclusion soundly supported by the framers' intent and the weight of the relevant authorities that Section 3 of the 14th Amendment is not self-executing, and that Congress alone is empowered to pass any enabling legislation. Because what did the majority decision do? They found a way to say, it's automatic, it's self... Oh, the dog just kicked open the door here. Come on, Pudge, let's go. No, get out of here, Pudge. The majority decision said, we found a way to basically say that we can disqualify without any federal congressional hearings. Nothing. We declare at the state level the disqualification of a federal presidential candidate, the presidential candidate, self-executing. We declare that he engaged in insurrection, even though there were no criminal charges, no criminal convictions. Boom, we did it under our Colorado electoral provision codes, and just declare. That's it. We don't need Congress. We don't need a constitution. We, the state, decide to disenfranchise the rest of the country if they decide to vote for this president that we've kicked off our ballot. That's how it works. 281. Moving on. 283. Pertinent procedural posture. Listen to this. The court ruled in conclusory fact, and that means they just pulled it out of their big kangaroo pockets. In conclusory fashion, willy-nilly, whatever the hell they decided, that states are empowered to execute Section 3 via their own enabling legislation, and that Colorado's election code constitutes such an enactment. This analytical shortcut, though convenient, y'all are a bunch of lazy partisan hacks, is what the Judge Samour is saying right now, more politely, however, is inconsistent with both the text of the 14th Amendment and persuasive authority interpreting it. Y'all don't know what you're talking about. I don't know when I started saying y'all. I love it. I'm going to do it for more. Just summary fashion. You guys just decide. Yeah, we're going to interpret and impose Article 14, subsection 3 of the Constitution at the state level, given our electoral college, electoral procedure. rubbish. And this judge is calling it out in as a judicial slapping, spanking of a manner as he can, but cloaking it under politeness, which I'm not always good at doing. Paragraph 289. Listen to this. Crucially, he observed that it is obviously impossible to disqualify certain officers by simple declaration, whether in the Constitution or in an act of Congress, citing one of the authorities. I forget which one it was, but it doesn't matter. One of these people, or at least three of these people, have a better understanding of history than four of those partisan hacks. Paragraph 292. Just going to keep going down here. I extract from three seminal and related takeaways from the review of Griffin's case. I think that might have been Griffin's case, but I might be wrong, so don't quote me on that. And look, I can't really understand the impact of the Griffin's case. First, Section 3 is not self-executing. You don't get to say it's automatic. We don't have to go through any congressional federal procedure. We just declare it. It's not how it works. Despite what they decided they were enabled to do, empowered to do under their Colorado election rules. It's not self-executing. Secondly, only Congress can pass, quote, appropriate legislation, end quote, needed to execute it, to disqualify the presidential candidate. And third, the grant of power to Congress was not merely formalistic, it was also pragmatic. There was a good reason why they did it. Indeed, it was indicative of the complex nature of the disqualification function, not just a bunch of partisan hack judges at the state level saying, well, our state election rules allow us to make a federal determination that can affect the outcome and future of the country. With just four of us, no hearings. By the way, he gets into the fact that they didn't have any meaningful hearings. There was they didn't respect the delays under their own state procedure. They tried to rush through substantive hearings willy-nilly. Just allow hearsay evidence, this and that. Just pull it out of your butts. But that was not the highlighted part. This is the highlighted part. Chief Justice Chase perceived that Section 3 would require an array of mechanisms, procedural, evidentiary, and definitional. He's going to get to the fact that, also insurrection has a criminal meaning. You don't just get to pick the dictionary definition when you want to ascertain who was subject to disqualification and how they could be disqualified. I'm choking on my own tongue here. More on this third notion later. Okay, then we scroll back down here. I love this. Paragraph 330. Listen to this. This is one of the judges. Might be a fresh convert to the Republican Party, to the conservatives, maybe to the populist movement. Colorado's election code cannot supply what Congress has withheld. Yet you all remember, and I've been saying this from the beginning, Trump was acquitted on his second impeachment, which related to charges directly related to January 6th. They went with the constitutional remedy, and he was acquitted on that constitutional remedy. And now this state court willy-nilly, unilaterally declares insurrection, notwithstanding the acquittal on the second impeachment based on those very charges. You know where you get to do that? In North Korea. In Russia, in a kangaroo court in which these four majority judges are warming their hands in their kangaroo pouches. Listen to this. There is paragraph 330 for those of you who want to check me. Paragraph 330, there is zero authority permitting state legislatures to do that which, though delegated to it, Congress has declined to do. The majority, however, holds that the electors' 14th Amendment claim can be brought under sections 1-1-113 and 1- of Colorado rules of whatever it is, the Colorado Election Code, because the Secretary's listing of a constitutionally disqualified candidate on the presidential primary ballot would be a, quote, wrongful act, and that term is used in section 113, whatever. But the truncated procedures and limited due process provided by sections 1.1 or 1-1-13 and 1-4-1204, paragraph 4, are wholly insufficient to address the constitutional issues currently at play. Translation from someone who just got their judicial's butt slurved in their faces. You messed around, you bypassed everything, you denied Trump due process. But wait, there's more. Paragraph 338. Given the complexity of the legal and factual issues presented in this case, it's understandable why the district court may have felt that adhering to the deadlines in their own rules under the state law, I won't mention it again, 1-4-1204-4, I just mentioned it, wouldn't allow the parties to adequately litigate their issues. But the district's court didn't have the discretion to ignore those statutory deadlines. You ignored your own statutory deadlines. You rushed this through. You denied due process. You allowed evidence of hearsay grubbish. Grubbish. It's a new word. It's garbage and rubbish. Grubbish. Because you wanted to allow it in. You found a way to allow it in that January 6th partisan kangaroo court committee. You didn't have the authority to bypass your own statutory guidelines, a time frame. But you did. Why? I hate Trump is why you did it. Listen to this. Oh my God. If I were the 4 majority judges, I would be ashamed to leave the House for the rest of my life. Paragraph 341. There was no fair trial either. Listen to this. President Trump was not offered the opportunity to request a jury of his peers. Experts opined about some of the facts surrounding the January 6th incident and theorized about law, including as it relates to the interpretation and application of the 14th Amendment generally, and Section 3 specifically. And the court received and considered a partial congressional report, the admissibility of which is not beyond reproach. Judicial translation, you had no business allowing that Jan 6 committee report as evidence. None. Garbage. Garbage in, garbage out. Welcome to the majority decision. Oh my goodness. Paragraph 342. I have been involved in the justice system for 30 years now, and what took place here doesn't resemble anything I've seen in a courtroom. First of all, Judge Santour? Oh geez, I forgot your name. Congratulations, you don't look like you could have possibly been on the bench for 30 years, but good for you. I've been on the bench for 30 years. This is not justice. This is an outrage. In my experience, in our adversarial justice system, parties are always allowed to conduct discovery. Oh, God forbid. Conduct discovery? Denied discovery. Subpoena documents. They were denied the right to subpoena documents. And compel witnesses. Had they compelled witnesses, they might have understood that Kylie, who said bring in the cavalry, was not a typo. She meant Calvary and not cavalry. They might have understood that. They bypassed every aspect of due process to get to this kangaroo court decision, majority 4-3. Good for those, and God bless those three dissenting justices. In my experience in our adversarial system, justice parties are always allowed to conduct discovery, subpoena documents, and compel witnesses, and adequately prepare for trial. And experts are never permitted to usurp the role of the judge by opining on how the law should be interpreted and applied. You could not get more of a smackdown if you tried. This is a thing of beauty. Paragraph 348. More broadly, I am disturbed about the potential chaos wrought by an imprudent, unconstitutional, and standardless system in which each state gets to adjudicate Section 3 disqualification cases on an ad hoc basis. Surely this enlargement of state power is antithetical to the framers' intent. You are correct, Judge Samour. And don't call me Shirley. Bada bing, bada boom. And then I can read the conclusion, which I will just for the sake of it. In the first American Declaration of Rights in 1776, George Mason wrote that, quote, no free government nor the blessing of liberty can be preserved to any people but by the recognition by all citizens that they have rights and that such rights cannot be enjoyed save in a society where law is respected and due process is observed, or process, depending on if you're American or Canadian. Some 2.5 centuries later, those words still ring true. In 2023, just as in 1776, all, including those people who may have committed horrendous acts, are entitled to procedural due process. Because I cannot, this is paragraph 350, the last paragraph of Judge Samour's dissenting opinion. It's a thing of beauty. Because I cannot in good conscience join my colleagues in the majority in ruling that Section 3 is self-executing and that the expedited procedures in our election code can have afforded President Trump adequate due process of law, I respectfully dissent. There you have that. After I'm done smacking you around, calling you a bunch of hacks, liars, cheats, procedural cheats, I respectfully disagree. Given the current absence of federal legislation to enforce Section 3, and given that President Trump has not been charged pursuant to Section 2383, remember that old provision of law about sedition and insurrection? Hasn't been charged, let alone convicted. Because he hasn't been charged, this district court should have granted his September 29 motion to dismiss. It erred in not doing so. I would therefore affirm its judgment on other grounds. Actually, not quite sure what that last sentence means. That's pure judicial destruction. And he's right. It's not a question of being partisan. Like, oh, okay, well, I want to agree with Judge Samour, and I don't want to agree with the hacks of the majority. You've heard both positions. One is objectively right and one is objectively wrong. One is objectively right for all of the right reasons. No due process. You can't disqualify at the state level, have the states willy-nilly usurping federal powers. The chaos aspect of it. You can't flippantly go through this process. Oh yeah, no, we're just going to jam through a 5-day hearing on whether or not we disqualify a presidential candidate. You've heard both decisions. You've heard both motivations. If you don't agree that one is right and one is wrong, Well, then we'll agree to disagree. But I think everyone with half a brain who understands this now and who has taken the time to understand the majority and the dissenting opinion, 4-3 nonetheless, knows one is right and one is wrong. Now, with that said, I've been staring at this for the longest of times. I said 10 minutes. We're now on 20. I'm going to publish this unedited because the world needs to understand this in real time. Don't freak out. Don't overreact. And understand that even in your blue Colorado, with your 7 Democrat-appointed judges, there were 3 Democrat judges on that court that disagreed with the Kangaroo court and that took paper to pen, or at least digital paper to pen for me, for an eternity to give them the judicial smackdown that they deserved. So Justice Samour, Justice Boatright, and the 3rd dissenting judge, hold on, cannot ignore the 3rd dissenting judge. So let me just see if I can get to it real quick like. Justice Samour, Justice Boatright, and I'm going to do it. I'm going to take a few seconds more than I should here to do this because we must give credit where credit is due. Procedural history, so I know I'm getting up to the name. Justice Birkencotter. Justice Birkencotter. Birkencotter, Samour, Boatright. Congratulations. Evil thrives when good people do nothing. All 3 of you did something good. So with that said, I'm off to Canada tomorrow. Merry Christmas, Happy New Year. I will give updates to let you know that I haven't been detained by Herr Trudeau. But that's it. Go. Now you know your vlog. vivabarneslaw.locals.com. Viva Frei on Rumble. The Viva Frei on Twitter. And if you want some merch for whatever the reason, vivafrei.com. Go. Peace out, peeps.